more than speculative chance of affecting them in the future.
Why didn't you challenge the November rule, or have you elsewhere?
We have 2 suits pending right now that would provide us the relief that we're seeking in some way or another. One is this, we believe, because again, the district court issued declaratory relief affecting our rights with respect to that subsequent rule that's based on the delay rules. We also have a motion to enforce the settlement that led to the January 2021 rule, the revision rule, pending for the last year and a half in district court. So we could, maybe we will.
Neither of those
please, no.
sound like substantive challenges to the November rule.
Well, Your Honor, a predicate of the November 2021 rule is that the delay rules challenged here prevented the prior administration's rule from taking effect.
I get that, but it seems like you could challenge the November rule and make the illegality of the delay rules part of your challenge to the November rules.
Your Honor, we would agree we can, but Union of Concerned Scientists shows that we don't have to, that this court has jurisdiction, that this case is not.
I mean, I'm not asking you to like reveal litigation strategy or anything, but it's just not clear to me why you didn't or why you wouldn't.
So
and I think speaks to the capable of repetition yet evading review. If you could do this, then by challenging the November rule, then it wouldn't be delay, it wouldn't be evading review.
So 2 responses on that. I think the predicate of your question shows that this case is not moot because the same issue is presented in the subsequent rule. Again, that's why Union of Concerned Scientists found that the subsequent rule that extended the safety equipment deadlines did not moot the prior rule on which that subsequent rule is based. And that's why Union of Concerned Scientists, this court said, it would squander judicial resources and the parties' resources to have to face the same issue again in challenging a subsequent rule. And especially here, where we challenged plaintiffs here, many of the plaintiffs here, challenged the prior 2012 rule. And it took 8 years to get to no decision at all, to get to a settlement. The challenge to the subsequent November 2021 rule would be far larger, far more complicated, a much bigger administrative record. And that record wouldn't even present the specific issues raised here, which we would again have to litigate in challenging that subsequent rule. This court, again, in Union of Concerned Scientists, said that it would make much more sense to challenge the rule that actually raises the issue, that decides the issue here, whether the prior administration's rule went into effect, to revise the critical habitat area for northern spotted owl, and to raise the same issue in a subsequent rule that only depends on that prior rule. So that's what we would do here. I would add.
And when you say the subsequent rule depends on the prior rule, you're talking about the effect of the delay rules, or you're talking about something else?
The subsequent rule depends on the delay rules having validly prevented the prior administration's rule from taking effect. So and
what you mean by that is that the subsequent rule could have never come into being if. What exactly do you mean in the chain of causation?
We believe that to be true. We think it's inherently arbitrary and capricious for the agency to say to the people of the Pacific Northwest that they're only helping, that they're reducing environmental impact, economic impact, removing areas from critical habitat designation, when in fact they were adding over 3 million. And based on that predicate, that the prior rule never took effect, the agency did find that it could take a shorter process to.
No, but when you say the prior rule never took effect, you're not talking about the delay rules then.
We're talking about the January 2021 rule, which we moved over about 3.5 million acres in the critical habitat designation for northern spotted owl.
Which the November 2021 rule displaced.
Which the delay rules prevented from taking effect, and then the November 2021 rule replaced, assuming that it had never taken effect. That's exactly the situation in NRDC v. Abraham, where there was a prior rule, delay rules delayed the effective date of that prior rule. Then the agency issued a subsequent rule that assumed that the prior rule had never taken effect. What the Second Circuit found in that case was that the challenge to delay rules remained live because the subsequent rule depended on the prior rule here, the January 2021 rule, never having taken effect, never having changed the critical habitat baseline here, the northern spotted owl. So yes, the subsequent rule does depend on the challenge, the delay rules here, on their validity. So the district court could issue relief that affects the subsequent rule. That type of declaratory relief, even injunctive relief, is available where it would affect the party's rights, where a subsequent agency action is based on an action that this court finds unlawful. One more point on why we don't challenge subsequent rule. I think the respondent's brief here shows that they will try to procedurally box us if we abandon this case. They argue that the presumption of agency regularity means that when they issued that subsequent rule, all that really mattered was that they reasonably believed that the prior rule was valid, not that it was actually valid. But that's yet another reason, in addition to the fact that we've already briefed this in district court, ready for decision. It was ready for decision for 6 or 7 months more, I think, before the time the court dismissed the case as moot. After the defendants here repeatedly invited the district court to not reach the merits of the case because, quote, events would soon overtake the challenge here.
I think the government is likely to say that the precedent you're relying on, they had delay rules, but they also had substantive rulemaking in them as well. So what's your response to that?
Our response is that it's very substantive that the subsequent rule assumed that the critical habitat baseline on which the agency acted was 3.5 million acres.
And maybe I'm misunderstanding their argument, but I think it's not that in the precedents, the equivalent of the November rule had substantive rulemaking. It's that the equivalent of the delay rules had substantive rulemaking in addition to the procedural delays.
So that was not the case in NRDC v. Abraham. It was that the delay rules, had a substantive effect, but what was at issue was the delay itself, which was issued without notice and comment. That had substantive effect in that it set the baseline for the subsequent rule. That's the same situation in Reno v. Bossier Parish School Board under the Supreme Court. The Supreme Court held that a challenge to a voting plan or districting plan for one election that had already occurred didn't become moot, not because it would be the same plan for the next election in 10 years, but because it set the baseline for that next election and the plan that would be required then. So it is substantive. Your Honor, turning to the capable of repetition but evading review, just briefly, I'd like to point out.
Take just a little bit, and then we'll hear from the government. We'll give you a little time for rebuttal.
Okay. I'd just like to point out a couple things. One thing, and that is that, again, the history of presidential freeze memorandum shows that this case is capable of repetition and affecting plaintiffs' broad interests here, which span federal forests. We cite to the Biden administration's freeze memorandum and say that is part of that line of evidence. In fact, the Biden administration also delayed a rule issued by the prior administration under the Migratory Bird Treaty Act without notice and comment, effective immediately, that affects plaintiffs' rights here. So the American Forest Resources Council opposed that delay and supported the prior rule and opposed its replacement. It even affected northern spotted owl. The Migratory Bird Treaty Act rule that this administration delayed. So to say that this type of delay tactics is not capable of repetition, I think ignores the broad scope of the plaintiff's interest here and the history of this type of delay tactic.
And when you say delay tactic, what exactly are you talking about with the tactic? The delay rules themselves, or
The legal question presented here, I think, fundamentally is whether an agency can prevent a prior administration's rules from taking into effect by issuing successive delays, by issuing delay rules, because they want to reconsider the rule. And this court, in cases like Air Alliance Houston and others, has held that you can't do that. And I think just to make this point, Air Alliance Houston v. EPA, this is 906 F3D 1049. There, this court vacated 20-month delay rule, and it ruled that EPA may not employ delay tactics to effectively repeal a final rule while sidestepping the statutorily mandated process for revising or repealing that rule on the merits. So what this agency has done is to package in several steps what it couldn't do in that case in one, and get review in one longer delay. And the records before the court, I think this is even different than other cases that are likely to present the same facts. Records before this case show that the agency planned from the outset a three-step delay, replace process, having drafted the delay rules within days of the Biden administration. Then it proceeded to issue successive delays without notice and comment to prevent that prior rule from going into effect. And so I think there is very much evidence of manipulative intent here.
Okay. Why don't we hear from the government, and we'll give you some time for rebuttal. Unless my colleagues have other additional questions. Okay. Thank you, Mr. Welty. Ms. Pepin?
May it please the court, my name is Joan Pepin on behalf of Williams and Ms. Halen. This court has recently held twice, and has for decades held, that it is such a well-settled principle that when an agency action has been superseded by another regulation, that litigation over the legality of the original regulation becomes moot. This is such a routine matter that it's usually dealt with in an unpublished order. Plaintiffs say that this case is an exception for the reasons that you heard. They maintain that the delay rules changed the status quo in such a way that the November rule depends on it, and so it still has, in their view, continuing consequences. We don't agree with them about that, but that's not really a question for this lawsuit. That's a question for a future lawsuit challenging the November rule, and contrary to what Mr. Welty suggested, we do not argue. They cannot raise that issue in a future challenge to a final agency action to which it is relevant, if that action remains live. But that's not the case here. Here, even if you assume their position that the November final rule in some way depends on the delay rules, that would at most establish an injury that is traceable to the delay rules. What we still don't have is redressability as a district court. And it's just black letter fundamental constitutional law that you must have injury in fact traceable to the defendant's action that is redressable by a judicial order at all stages of the controversy. And without it, the action must be dismissed, no matter how judicially inefficient that may be. It is a fundamental principle of the separation of powers, going back to the founder.
Did I hear you to say that in a future case, if the November rule is challenged and the delay rules are challenged at the same time, that court could decide the legality of the delay rules?
Yes, they could decide it because, assuming plaintiff's theory that the delay rules are invalid, that the November rule is invalid unless the delay rules were effective, they can certainly make that argument, and a court could address that argument and decide the legality of the delay rules en route to that holding.
But you would argue that the November rule is valid regardless of the legality of the delay rules, and you would probably tell the court, therefore, you can't decide the legality of the delay rules because it's irrelevant.
No, we would disagree with their argument on the merits, but not that the court wouldn't have jurisdiction to consider it. This sort of thing happens all the time. For example, when there's a challenge to a site-specific agency action that is backed up by a programmatic document, challenges to the programmatic document can be brought through the site-specific action. And this would be a similar situation where, to the extent that their challenge to the November rule depends on saying that the delay rules were ineffective, they would be free to make that argument in an action where there was a live agency action to which it was relevant. But this is not that case anymore because the delay rules that are under challenge here have expired. So there's no redressability.
Why wouldn't that be the case in the subsequent hypothesized suit also?
Because it wouldn't be setting aside the delay rules, it would be setting aside the November rule on the theory, their theory, which we oppose on the merits, but don't say that they can't make it, that basically, unless the delay rules were effective, the November rule falls. That's their argument. We don't agree with it, but that's a merits argument about the November rule. It's not before this court, and it's not relevant to the question of whether this challenged the delay rules. The Abrahams case is a case in point. The difference between that case and this one, and it's all the difference in the world, is that in that case, the court had the final substantive rule, the equivalent of the November rule, before it, because the plaintiffs had challenged that as well. And so the court did exactly what I'm saying this court could do in a future challenge. It considered the legality of those delay rules as it affected the final substantive rule, which was before the court. Because the final substantive rule was before the court, they had redressability in that case. They could set aside the final rule, which they found in that case actually did depend on the delay rules because of an anti-backsliding provision in the substantive law.
Mr. Welty said that in that hypothetical case, he would expect you to make an argument about presumption of regularity, something along those lines.
There, of course, is a presumption of regularity, but plaintiffs are allowed to bring challenges to rebut that presumption. And so they certainly can, we've never said that they couldn't make this argument in a live case. They can challenge the November rule. They can make any arguments against its legality that they wish, because, as long, unless it gets superseded, because the fundamental rule is that when an agency action is superseded, then litigation over the legality is moot.
Putting aside the November rule, what do you think are the chances that this will recur?
The chances of critical habitat someday being amended is reasonably likely.
And the chances of a delay rule?
Well, see, now that's much more unlikely.
It's happened to every administration, right? Past six.
But not to critical habitat. Yes, there have been, I think 4 times in the last 30 years, critical habitat has been amended. But this is the only time that it happened kind of on the cusp of an administration, such that before it even went to an effect, it was delayed and then replaced. But most of the time, it doesn't happen with that precise timing, and there's no reason to believe that that will recur. Now, will there be other agencies that will publish, the likelihood of some plaintiff someday challenging one of these delays, again, is reasonably likely, but that's not enough to establish the capable of repetition yet evading review. And I would quote this court from Planned Parenthood, said, in other words, the capable of repetition exception permits adjudication of an otherwise moot case on the theory that it is capable of repetition. The exception does not permit the adjudication of one otherwise moot case in anticipation of a different live one. If the exception swept that broadly, it would be inconsistent with the Constitution's requirements set forth in Article 3 that courts resolve only continuing controversies between the parties. So the abstract issue of what they're calling a dawn delay of a midnight rule may certainly recur, but that's not enough to keep this case alive. And also not enough to keep this case alive.
It does seem maybe strike me as I don't know if uncomfortable is the right word or odd. Imagine that you're right, that the November rule is going to be valid, even if the delay rules were illegal. Administration after administration could do illegal delay rules. And so long as the substantive rule is still valid, those delay rules, illegality will never go unchecked, ever.
Well, there's no reason to believe that all delay rules evade review. I'm not familiar with the last case Mr. Welty cited, but he did mention that there was a 20-month delay rule at issue in that case. You're not inherently evading review. In this particular case, the agency came out with the superseding final rule relatively quickly, but that is by no means typically the case for critical habitat rules or for, nor is it true that delay rules are generally short. I also want to respond to this argument that the fact that there were 2 delay rules suggests some kind of bad faith on the agency part. That is, the fact that there were 2 delay rules is a pure red herring. It made no difference. The second delay rule didn't moot the first one, and we didn't argue that it did. It didn't move to dismiss on that grounds. We moved to dismiss as moot after the November rule superseded the delay, and the delay rules had expired by their own terms. So I'm not sure that the fact is this first delay rule was short in duration for a very good reason, so that the agency could take notice and comment on whether to continue delaying it and whether to pursue a full rulemaking on the critical habitat rules. And this is plain on the face of the rules, and the idea that the November rule was issued to end this litigation, this was some manipulative ploy to get out of this delay rule litigation, really makes no sense when you look at the big picture. Obviously, the delay rules were there to enable the agency to reconsider, or to consider whether to issue what changes to make to critical habitat, and it's not the other way around. The final rule wasn't to serve the delay rules.
Can I just ask, if there's a suit that's a challenge to the substantive bona fides of the November rule, and in that suit, there's a challenge to the validity of the delay rules, then what you said earlier is that that challenge to the validity of the delay rules would be resolved in the course of the challenge to the substantive validity of the November 2021 rule, as long as the argument was being made that, look, because the delay rules were invalid, the November 2021 rule would have never come into being, but for the now, we would say, putatively invalid delay rules.
Right, and that would be like the Abraham case, where the delay rules were adjudicated in the context of a challenge to the action that they allegedly, and in that case, in fact, the invalidity of the delay rules did take down the final rule in that case because of the anti-backsliding provision in the substantive law. So yes, it can be adjudicated in a live controversy in which it's relevant.
Right, and why wouldn't a challenge to the November 2021 rule be a live controversy?
It would be. I mean,
Okay,
unless
right.
it's
So-
killed or something, yeah.
Right, so I guess, as a follow-up to Judge Walker's question, so the question was, if administration after administration is using delay rules and the delay rules are invalid, then is there any way that the invalidity of those delay rules will ever be adjudicated? And would it not be in the kind of case that we just hypothesized?
Well, and perhaps I wasn't, the answer I was trying to give to that is there's nothing inherently evading review about delay rules. They aren't always short. There have been some cases where they've gone on for several years. Some of the delay rules suspend a deadline indefinitely. These ones were short.
Right, so that would mean that there would be a direct challenge to the delay rule itself before it expired.
It's quite possible that somebody could challenge the delay rule and litigate it to finality. Moreover, in this case, they did move for a preliminary injunction and then didn't appeal the denial. So I know this court has held in Newdow and in FAA versus Armstrong that when when a plaintiff requests preliminary injunctive relief in the district court and then does not appeal it, that is also a reason for finding that it does not evade review. But ultimately, this case does not evade review because they didn't appeal the preliminary injunction, because delay rules don't inevitably evade review, they're not inevitably of short duration, and finally, because review is available in a challenge to the final November rule.
Review of the delay rules is available in a
Sorry?
challenge. Review of the delay rules
Well,
are available.
yes, insofar as they affect the validity of the November rule. Right.
Okay.
If they did not affect the validity of the November rule, then the validity of the delay rule could not be challenged in a challenge to the November rule.
I'm sorry, the
Ima-
echo is making it very hard.
So imagine a challenge to the November rule,
Yeah,
and imagine that the validity of the November rule does not depend on the
I see.
validity of the delay rules. If that's the case, then the validity of the delay rules could not be challenged in a challenge to the November rule.
no, I mean, if it's not relevant to the issues, the validity of the live agency action, then it wouldn't be an issue in that case.
And you say no, but you mean you're agreeing with what I said.
I hate to say I agree when it's not catching every word because of the echoes.
Sorry.
So sorry about that. But yes, the issue can only be adjudicated in a case in which it is relevant to the validity of the action under review. So.
And can I just, I'm just trying to understand what does it mean that the delay rule validity is relevant to the validity of the ultimate rule? Suppose the argument is that the ultimate rule would have never come into being if the invalid delay rules hadn't been in place, and they should have never been in place because they're procedurally invalid. They were adopted without notice and comment or something like that. And that's asserted to be the relevance to the ultimate rule, is that, well, the ultimate rule just wouldn't have come around. Is that relevant?
I mean,
is that the kind of relevance you're talking about?
These arguments, the hypothetical arguments, will have varying degrees of strength, right? In Abraham, it was very strong because the substantive statute said you can't loosen the rules, you can only tighten them. In this case, they have an argument that you've heard them, you know that the November rule depends on the number of acres of critical habitat that were already designated, and what that number is depends on whether the January rule ever went into effect. In litigation over the November 2021 rule will be the opportunity for a court to decide whether that's correct, whether it really does depend. And if the court thinks it does depend, then it will have to decide whether the January rule went into effect. But that's not an issue for this court. So yes, a very far-fetched rule about a long series of events that might never have happened might not be a relevant issue for a court to decide. But in this case, I don't think there's any. We certainly wouldn't argue that they can't make that argument. So it does not. Well, we ask that the court affirm the district court's correct judgment. That this court affirm.
Thank you, Ms. Pepin. Mr. Welty, we'll give you 2 minutes for rebuttal.
Thank you, Your Honors. Defendant's argument here would render the continuing consequences doctrine a nullity. This court has repeatedly held that where an expired or superseded rule or action has continuing effects, the challenge to that action is not moot. I'd like to address too the fact, well, on that point, there shouldn't be any surprise that the delay rules have continuing effect, because that's exactly what they were intended to do. They were intended to prevent the prior rule from going into effect before the agency had time to review and replace it, so that it didn't change the critical habitat designation for northern spotted owl when it subsequently acted. I briefly addressed the argument under Newdow.
Why doesn't that tell us just that the continuing effect continued until the final rule was issued? Why is that still a continuing effect?
It's a continuing effect because, like in Reno v. Bossier Parish School Board, and like in Abraham, and like in NRDC v. EPA, the delay rules, the prior rule, had set the baseline for the subsequent action. And it was a 3.5 million acre difference.
Right,
We pointed out that's the size of Connecticut. It affects the parties' rights. It affects the obligations that the service had issuing that subsequent rule. This rule is absolutely a live one presented by adverse parties for decision here. And that's enough for the district court to, at the very least, issue declaratory relief that the prior administration's rule went into effect. We can take that ticket into...
It just seems like that's an advisory opinion for the benefit of a challenge to the November rule.
It is not advisory because it decides a real issue that has a more than speculative chance of affecting the parties' rights. It presently affects them. It means that the foundation of the subsequent rule...
I don't see how it does, because it doesn't make you any better off. The November rule would still be in effect until the November rule is challenged.
Again, I think that the district court would have authority in finding an agency action unlawful to affect injunctive relief and decide whether an agency action that is then taken based on that action.
So you think the district court could enjoin the November rule?
It could, well, NRDC v. Abraham, just to provide an example,
I think that was a challenge to the final rule and the delay rule at the same time.
They were consolidated. But what the court decided was that the delay rules were unlawful, and it set them aside. And it declared that the prior administration's rule went into effect.
In a suit where the validity of the final rule was at issue.
Maybe we have to go and file another suit, but that just goes to show again that the same issue is going to be presented here. There's an ongoing position or policy, right, that the prior administration's rule didn't take effect. That's presented by the parties here in a challenge to the rules that purport to have prevented the prior administration's rule from taking effect. So it makes much more sense for a court to decide the validity of the delay rules in a challenge to the delay rules. The fact that the next administration's, that the next rule depends on those delay rules goes to show that the continuing and collateral consequences doctrine applies.
Do you know where a challenge to the November rule would be filed? I mean, I could have looked this up, but would it be in our court or would it be in a different court?
It would be in district court. And that's one thing that
In DDC?
In DDC. Would be related, I'm sure, to the existing cases. Again, it would take a very long time for it, based on past practice, for it to be decided. Whereas if we were to get a declaratory relief on an issue that affects our rights now, we could, if necessary, if the agency doesn't do the right thing, as we put it, as we see it at least, file a subsequent suit.
You have no, I think you have no precedent where there was a challenge to something other than the final rule. You have no precedent where there's a challenge to a delay rule that did not include a challenge to the final rule. And the relief afforded was an invalidation or injunction against the final.
We have cited to precedent where a challenge to one rule affected the validity of the subsequent rule.
But that was one substantive rule.
A subsequent rule and also a subsequent delay rule. So NRDC, the EPA, the court found that the challenge to the first delay rule meant that the subsequent delay rules, which depended on the first delay rule, were also invalid. Again, this just goes to show that declaratory relief here is available because it would affect the parties' rights. There's a real dispute between adverse parties that continues in a subsequent action and continues in an ongoing position or policy that the prior administration's rule never took effect. And just finally, Your Honor, I would like to point out in response to the argument under Newdow and Armstrong that this case is controlled by Rawls, which is cited in the brief, and not by those cases. Rawls presented a short-term delay like these. Evades review means evades review by the Supreme Court. There is no way we could have got to the Supreme Court if we had pressed our deny motion, which wasn't even decided on.
All right, let me make sure there's no further questions. Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 22-1101 et al. Alabama Municipal Distributors Group et al. Petitioners versus Federal Energy Regulatory Commission. Mr. Matthews for the petitioners Healthy Gulf and Sierra Club. Mr. Elliott for the petitioners Alabama Municipal Distributors Group et al. Ms. Benta for the respondents. Mr. O'Neill for the respondent interveners.
Morning, counsel. Mr. Matthews, please proceed when you're ready.
Thank you, Your Honor. Good morning. Nathan Matthews on behalf of petitioners Healthy Gulf and Sierra Club. This case challenges the Evangeline Pass pipeline project, which would supply gas to the Plaquemines liquefied natural gas export terminal. Evangeline Pass is one of 5 different dockets FERC has prepared relating to this terminal, and Evangeline Pass would supply roughly a quarter of the terminal's gas supplies. I'd like to discuss 3 issues today relating to connected actions, indirect effects, and climate, and I'd also like to briefly address remedy. On connected
Briefly,
action,
what was the last thing you said you'd like to briefly address?
sorry,
What was the last thing you said?
remedy.
Oh, okay.
On connected actions, FERC argues that the terminal and the pipelines are not connected because they are not interdependent. This is factually incorrect. The terminal needs the gas that the pipeline would supply. The EIS found that there was no existing or proposed pipeline that could provide a substitute. FERC found that if they had to construct a new pipeline to replace Evangeline Pass, it would be 175 miles at an added cost of $1.4 billion.
Can you clarify what you mean by needs? And I was confused about this in the brief too. The terminal is getting gas from multiple pipelines. And if it doesn't get gas from this pipeline, are you saying the terminal doesn't work? Or it just
So
won't
the
be
terminal's,
at full capacity?
it doesn't work at full capacity. I mean, the terminal works to export gas, and so it can't export gas without gas.
So that
export.
pipeline is really not required.
Well, the terminal was proposed to FERC as a pipeline that would take 3.8 million decatherms per day of gas and then export it. So the project, as contemplated by FERC, can't go forward. If they were only going to build a pipe,
But the terminal, I think you've already answered it, but the terminal will serve a purpose, even if this pipeline isn't one of the pipelines that feeds into it.
the terminal could, portions of the terminal could run without this pipeline. You could build half of it and only use half the supply. But there's no way to do the full proposed and approved activity without the full volume of gas.
And just on this topic, it's just a clarification question. I think it's page 5 of your reply, although I could be misremembering. There's this really helpful, yeah, it is page 5 of your reply.
The graphic,
Yes. It was very.
5 of our reply.
Thank you for it. But the numbers don't quite add up. And I wondered what's that all about?
I don't know. It would have been very helpful if FERC had given us a graph like this, a map, a diagram, anything else in any of these 5 FERC dockets. My suspicion is that balance of gas may be burned in the Gulf Express pipeline to power the compressor that then moves to gas, but I don't know.
Okay.
So factually, the terminal cannot do everything it said it's going to do without this gas, and it's not spare change at the margin. More than a quarter of the gas that the terminal needs. But even if FERC was right that the terminal did not strictly depend upon the pipeline, interdependence is just one of the 3 regulatory definitions for connected actions. Clause 2 of the regulation says that actions are connected where one, quote, cannot or will not proceed unless other actions are taken previously or simultaneously. And FERC has explicitly adopted CEQ's regs on this. At 18 CFR section 380.1, FERC says we're going to follow all the CEQ regs. But FERC never addressed that regulatory text in its orders, didn't explain why it doesn't apply here during its brief, but it's clear that it does. That Evangeline Pass would not go forward without the terminal. It serves no other purpose. And where this court has rejected segmentation arguments, the court has found that each segment had substantial independent utility. So if Evangeline Pass has no substantial independent utility, that itself clearly distinguishes this from all of the prior segmentation cases.
Can I ask you a question about significance?
Of greenhouse gases?
Yes.
Yes.
Imagine I look at the significance discussion in this EIS, and I compare it to the significance discussion in Center for Biological Diversity, last term's case out of Alaska. And I think the discussion was more thorough in this case. Does that mean that you lose on significance?
No, Your Honor.
Tell me why.
Because in this case, FERC provided a very different rationale for not discussing significance than in the Center for Biological Diversity.
Say that again.
FERC's rationale for not making a significance determination here is very different than what FERC articulated in Center for Biological Diversity. In particular, here, FERC did not claim that it had no way to determine significance. FERC pointed to its pending policymaking to say that we are still figuring out the best way to do it. But FERC did not claim we can't or we just don't know how, that we haven't decided how yet. And FERC cites no authority, and I'm not aware of any, that says the promise to do better in a future proceeding excuses you from making a required determination now, where the agency hasn't given an explanation as to why it can't make it now, just saying it would rather wait into it later. As to social cost of carbon particularly, the court, or FERC here also didn't articulate two of the three arguments that were at issue in Center for Biological Diversity, as we explain in our briefs, but I don't think that the court needs to reach the social cost of carbon arguments because of the importance of FERC's concession up front that it just had not decided how to make a significance determination.
But so what if FERC had not gone down the road at all? Because is your argument predicated on the idea that there was the initial rule and then it was converted basically to draft status?
No, I mean, that would have, FERC presumably would have needed to offer a different rationale as to why it wasn't making a significance determination here, but we don't argue that the requirement to decide whether greenhouse gases are significant or how significant they are arises from FERC's rule. That comes from the NEPA regs that says agencies must evaluate the significance of effects. And it has consequences. I mean, it's not just we want to know. I mean, FERC typically requires mitigation for significant effects, whereas FERC has said for greenhouse gases in the past, the reason they are not requiring mitigation is because they don't know whether the greenhouse gas emissions are significant. When it's reviewing alternatives, FERC typically will not require an applicant to adopt an alternative unless that alternative would offer a significant environmental advantage. So I do think that there's value in FERC just stating a position of, did we think that these emissions were something to worry about or not? But it can also change the contours of the rest of FERC's analysis. And so that's why we think FERC had the obligation to say something about whether or not the greenhouse gas emissions, whether we're talking direct emissions or emissions from the connected actions or indirect, whatever scope we're using, FERC has to take the emissions in that scope and say if they're significant or not. And here FERC said, well, we plan to do that. We've talked about a couple of ways we could do it, and we'll get back to you. But they didn't. But then they went ahead and approved this project without actually meeting the obligation that they had already recognized. I'd like to circle back to connected actions for just a moment and address FERC's argument that the cumulative effect analysis somehow meant that there was no need to discuss connected actions.
Excuse me, Mr. Matthews, for a moment. What's your FERC's experience with actually determining that something is or is not significant, that the emissions are?
FERC has only actually made that determination in a couple of cases. One is the Northern Natural case that we described, right, where FERC said, in that case, we don't know where the line between significance and insignificance is, but we're confident that this project is on the insignificant side of it, where the emissions were so low that solved the issue. Here, if FERC is required to consider either connected actions or indirect effects, then I think FERC could make the converse argument very plainly. FERC had proposed a threshold of 100,000 tons per year. If we're looking at the connected actions, but still the direct effects for infrastructure, we're already talking millions of tons per year. If we're looking at the whole life cycle effects, FERC had said that a pipeline that moves 1/200th of the gas of Evangeline Pass would have enough life cycle emissions to cross that 100,000 tons per year threshold. So maybe FERC doesn't know if it should be 100, 150,000.
So is that to say that the northern case is as close as they've ever come to actually saying?
FERC is extraordinarily reluctant to actually take a position on this. So I believe there's been one or two other subsequent cases like Northern that said this is too small for us to worry about, but otherwise FERC has not taken a position one way or the other.
And has survived challenge in Northern any other case?
I don't believe anyone has litigated the cases where they actually made a determination that emissions were insignificant.
So it sounds like they've been hesitant or waiting or refusing whatever for a long time.
This has been, this refusal has been a long-standing position of FERC's, but FERC's rationale has changed, and it changed dramatically when FERC published draft greenhouse gas policy. But I will say that Evangeline Pass is not a one-off. All of the other FERC decisions that were issued during that year, I think, also made the same argument about we are going to just figure out a way to do this sometime, but we haven't figured it out yet, so we haven't decided on which way to use yet, so we're not deciding significance.
So, but now they can say they're waiting on CEQ.
I mean, CEQ has encouraged agencies to go ahead and make that decision already while waiting for final guidance. CEQ has said you could use the social cost of carbon as one way to do it. CEQ hasn't set a threshold for a certain dollar value of monetized greenhouse gas emissions constitute significance.
Well, this isn't the first case where someone has argued that the agency had to adopt the social cost of carbon metric. Has any agency done that? It's not just FERC.
Oh, lots of other agencies use the social cost of carbon in project-specific reviews, as FERC has recognized. We cite FERC orders in the briefs where FERC acknowledges that maybe the Bureau of Land Management, the Forest Service, other agencies use social cost of carbon in their review, NEPA review for individual projects, but FERC has refused to do so.
Thank you.
But you don't think they need to, you don't think we need to get to the social cost of carbon anyway?
No, I mean, I think social cost of carbon is a great fallback option for FERC, but if FERC wanted to use its 100,000 ton per year significance threshold, if FERC wanted to adopt some other threshold, FERC just needs to make a decision so that we then can know, okay, well, when are projects going to require certain mitigation? When FERC approved this project, was its overall public interest balancing based on the conclusion that greenhouse gas emissions here were nothing to worry about, or instead did FERC have to decide these were a big problem, but the project is so important that it's worth it anyway? Once FERC picks a way to do it, then maybe we won't like that, but if we challenge that, that'll be challenging the agency's application of its expertise and judgment, and it would be reviewed under a different standard or different case than FERC's complete refusal to make a decision now.
So the agency could come back, as far as you're concerned now, and say, well, as we've said, we've looked at this in relation to larger emissions baselines, so state, national, and so on. And taking that into account, this is insignificant. End of story.
CEQ has encouraged agencies not to do that. So CEQ has said just saying that an individual project's emission are a small percentage of the state or national totals is not a good way.
But they're not bound by the CEQ, are they?
No, they're not. So
be part of your argument that this was
we think that FERC should not do that. And depending upon what FERC did, perhaps we would challenge that. But then FERC would be in the position of having made a decision and defending it rather than having just refused to make a decision. And I do think that the fact that FERC is refusing to make a decision here is somewhat telling. If FERC really thinks that these are nothing to worry about, FERC should say it. For whatever reason, FERC is uncomfortable saying that, and I think that the point of NEPA is to force agencies to ask these hard questions and to divulge their thinking to the public. The public should know whether FERC thinks that individual projects just aren't a problem for the climate because they're a small part of the total, or the public should know if FERC thinks otherwise. Well,
I mean, they haven't said irrelevant. They've simply said, I can't trace any consequence from a project level starting point.
FERC hasn't said you can't trace any consequences. They've said we can't trace it to direct physical effects. So they have said we don't know how many millimeters of sea rise we're going to get from this. But FERC's current position is that the social cost of carbon is valid. FERC's only criticism of the social cost of carbon right now is to say there's not a threshold at which monetized impacts become significant. But FERC does not dispute that the social cost of carbon is an accurate reflection of how much harm is going to be caused by greenhouse gas emissions.
And in this case, is that 137 million?
A ballpark.
Something
remember
like
exactly.
Yeah.
Yeah.
Okay. Thank you.
Looking just at the emissions from the direct infrastructure here. If you use a bigger scope, it's a much bigger. If you look at indirect or connected actions, it's a much bigger number.
But it's not just construction. It's not just construction.
No, infrastructure. So the pipeline compressor stations during the whole life of the project will operate and emit. I see that I'm out of time, and I made it through the first of the 3 points. If there are other questions, I'm happy to answer them, or we can.
We'll give you a little bit of time for rebuttal, Mr. Matthews. Mr. Elliott.
May it please the court, I'm Randolph Elliott on behalf of the Alabama Municipal Distributors Group and the other municipal petitioners. sometime next year, Southern Natural Gas Company will file a new rate case. Under the orders on review here, FERC has ruled that Southern can design those rates to over-collect its total cost of service. Southern, that's an uncontested fact. FERC approved, in this case, a lease, Southern's expansion of its pipeline capacity, a lease of that expanded capacity to its affiliate, Tennessee Gas Pipeline. Now, this is what's called a cheap expansion because the incremental costs of expansion are much lower than the pipeline's existing average costs, about half, less than half, according to the record here. Now, Southern leased the capacity to Tennessee at a negotiated lease rate that's about 25% higher than the incremental costs, lower than the average cost, but it's higher than the incremental costs. FERC ruled that the excess lease revenue above the incremental costs can be kept by Southern Natural Gas when it next determines its rates. It doesn't have to reconcile all of its costs and revenues in the next rate case. It creates two separate buckets. As a mathematical certainty, this allows Southern to over-recover its total costs of service. Now, we asked...
But not at your expense, right?
Pardon me?
But not at your expense.
Well, yes. I mean, Tennessee and its customers don't object to the lease rate. Our contention is that in the next rate case, you have to look at all the rate, all of the costs, and all of the revenues, and reconcile them, because a fundamental tenet of rate-making policy is that the pipeline is able to recover its total costs of service and not anything more.
That might make perfect sense going forward, I'm not sure, but I don't understand why it has anything to do with monies that have been captured during the current rate term.
Yes.
In other words, if the carrier made got a windfall from an investment in some stock issuance, it wouldn't redound to your benefit. They would keep it. If they realized a higher rate of return on their equity than was anticipated because of economies they could realize, they get to keep it. So how is this any different?
That's true. What we're saying is that in the next rate case, though, where they reconcile all the projected costs of service, all the projected revenues from the pipeline, you do take into account what's projected.
Well, that's going forward again.
That's our only contention.
But your whole argument seems to be you want credit for the 21 million that's going to accrue before the next rate case.
No, that's not. The pipeline interveners accuse us of asking for that, but that's not what we asked.
Well, then clarify.
FERC's very clear in the rehearing order, paragraph 18, what we asked for. A credit of the excess lease revenues in the next rate case or in future rate cases.
You mean to say any revenues that will be captured after the next, well, once the Section 4 case begins from this spur?
Yes.
Under lease.
Right. Yeah. No, we're not asking for an immediate, capture of the windfall.
And why is that timely now?
Why is that?
Why is that timely now?
Why is that timely now?
You raised that in Section 4.
Right. We addressed that, I think, in our discussion about standing, which nobody challenged. I understand you can address it. And FERC ruled with certainty that's how Southern is supposed to design its rates in its next rate case. It didn't leave that issue for determination in the next rate case. It's res judicata, if you will. And because that is an impending harm to us in the next rate case, it handcuffs us in the arguments we can make. With legal finality, we can challenge it now. In fact, we fear that if we waited and challenged it later.
So you read FERC as saying that in your later Section 4 case, they will not take into account the carrier's revenues from serving customers other than the munis.
Exactly. That is amazing. And that is what they ruled. You keep two separate buckets of costs and revenues.
Can you point that out? I'm sorry, I didn't come across this.
I'm sorry.
Where do I find that in the FERC order?
Well, it's Delphic, if you will, but the paragraph 63 of the certificate order says that in the next rate case, that's where they reject our request for the revenue credit. It says, Southern, we will require that during the term of the, this is the last sentence.
What page are you on in the appendix?
I'm on page 27 of the joint appendix.
27 of the,
Joint appendix, which is paragraph 63 of the order, page 27 of the order.
so. Give me a moment, please.
The last sentence says, we will require that during the term of the lease with Tennessee Gas, Southern will not be permitted to reflect in its system rates any of the costs associated with the lease capacity. Earlier in that paragraph, you say, and no revenue crediting either.
So you're saying that's for 20 years?
That's for 20 years. And the rehearing order doubles down on that rationale.
And
Says-
I realize your request is for credits from the revenue in excess of costs on this new spur, but it follows, does it not, that any debits would go to you as well, right, under your theory?
Well,
There's
I
a
mean,
catastrophe on the line, the contract is breached, and they get out of it, the shipper gets out of it, and the line or the LNG plant blows up, and there are no revenues,
right.
just costs.
Well, at that case, in the next rate case, they would have to, I guess, adjust the rates to.
At your expense.
On you?
Yeah.
You're acknowledging that that would be on you?
Well, what they have said is that all the what they've said is that all the costs and the risks of the expansion are on the pipeline.
The
Southern
sentence you
Natural
quote
Gas. That's a
refers,
key part of the
Your-
ruling.
But you want the costs and the revenues both to be to your benefit or detriment.
We're not trying to get a windfall here. What we're saying is that there can't be any over recovery of costs. You have to reconcile all the costs and revenues.
Okay, what about an under recovery of costs?
Under recovery of costs?
Means your rates will go up, correct? The costs and revenues have always traveled together,
Right.
right? I mean, we look back through all the changes that have occurred here and whether they were, specifically announced in Gulf South and all that, they've always been together.
Well, this order says that that rule no longer obtains, at least with respect to the costs. And we said, but what about the revenues? The excess revenues? I mean, if the pipeline wanted to lease some incremental capacity at a below-cost rate and eat the difference, it's free to do that. But that shouldn't come back to us. We can't subsidize the expansion. That's clear from FERC order, and they claim we're not allowing that to happen.
Okay,
That's paragraph
It
25.
sounds like you don't want to take the risk.
But also paragraph 57 of this.
Okay,
That's a fundamental tenet of FERC policy. We claim that right, that we should not subsidize this capacity. But let me explain to you why we are subsidizing the capacity. I mean, just do a mathematical hypothetical here that I mean, suppose a pipeline has a rate, average cost of $1. It doubles its capacity at an incremental cost of just 50 cents per unit. So now its average cost is 75 cents. It leases that expanded capacity for 60 cents. So it's a dime more than the incremental cost. Under FERC's rule here, the customers, my clients, still pay $1. The lease capacity is sold at 60 cents. What does that do? I mean, the pipeline recovers 80 cents average cost, more than its 75 cents actual average cost. So it's getting revenues more than its cost by keeping the two buckets separate and allowing the pipeline to keep the excess lease revenue. We didn't say go back, originally we said, your standard policy is to roll in a cheap expansion like that and charge everybody 75 cents. FERC wouldn't do that. They said no. So we said, well, all right, fine. If you're going to keep the lease rate at 60 cents, at least credit the excess revenue back to the total cost of service so that we don't subsidize the lease. In other words, in my hypothetical, the extra dime goes back to the original cost of service. The customers charge 90 cents, not $1. Lease is still 60 cents, no skin off their nose. It's 90 cents and 60 cents, that produces the average 75 cents. Pipeline recovers its total regulated cost of service, which is sufficient. FERC has found that it would be sufficient to attract capital, provide an adequate, reasonable return. We're held harmless, though, because now we're not subsidizing the lease, and the pipeline's ratepayers are not collecting, in effect, through the back door, a higher rate of return than their allowed rate of return. That's our argument. We're not saying you got to roll it in and give us a windfall. We're just saying don't allow us to subsidize the pipeline's rate of return. Total up all of the pipeline's costs and revenues in the next rate case, as you always do.
But it's subsidized in the Pickwickian sense, as Chief Judge was suggesting. It's not coming out of your pocket. You're claiming, I guess, it's an opportunity cost to you.
I think that's fair, if I understand your question.
Maybe this hypothetical can't happen, but imagine that things go haywire as a result of this expansion, and the average cost in your hypothetical, instead of going from $1 to 75 cents, goes from $1 to $1.25.
The pipeline, the FERC orders hold the pipeline at risk for the expansion costs.
You wouldn't have
Cost overruns, they're explicit about that.
Right. So you are looking to have your cake and eat it too. You want to pay less if the average costs go down, but you don't want to pay more if the average costs go up.
I don't feel like we're trying to have our cake and eat it
Forget
too.
about
what about the
that
latter
line.
part?
Is it true? Tell me if this is right or wrong. You want to pay less if the average costs go down, but you don't want to pay more if the average costs go up.
That's what FERC's policy holds. We're not supposed
that
No,
what
but
you
what do you
want?
want?
Yes.
Right, that's the debt. That just seems like the debt is a windfall. Because you're not willing to take the risk of the increased costs.
No, I mean,
You just want to bank the increased revenues.
yeah, in my hypothetical, we would be taking that risk if we said everybody should pay 75 cents. And let everybody's boat float or rise or float as the costs come. That's not what we're arguing. We're just arguing if there is excess lease revenue, and that's uncontested, there will be.
If heads, you win. If tails, they lose.
No, I mean, I would argue that the present FERC order is just the other way. The pipeline is to pocket the excess lease revenue at the customer's expense.
But the thing is, you're not the relevant customer in that situation because the costs aren't coming from you either.
Well, if you'll allow me, I mean, that's a fallacy, I believe, because the expansion here is a compressor station and 3 metering stations. Not 0 miles of pipeline. They're not constructing a new pipeline, leasing it. It's not even a lease of facilities. It's a lease of the capacity on the existing pipeline system. The expanded capacity is made possible by the equipment, the compressor, if you will, that enables a reverse flow on the pipeline. But it's the existing pipeline infrastructure that's being used. And they're not, that incremental rate, that 7 cents that they talk about, compared to the lease rate.
Okay.
That is based only on the cost of the compressor and the metering stations. It doesn't include any of the pipeline. So they're building this expansion capacity, if you will, on our backs.
Okay.
The pipeline capacity that we've already paid for, or are paying for in our current rates.
Let me make sure my colleagues don't have additional questions for you now. We'll give
Practical
you,
terms, the nature of the subsidy.
Okay, thank you. We'll give you a little time for rebuttal. Maybe we'll hear from the commission now. Ms. Vanta.
Good morning. I'm Carol Banta for the commission. I'll begin with the lease issue. I think the court understands it pretty well. There is no subsidy here, and I don't think that we had an argument raised that that these customers were subsidizing this. They do want the revenues, but I don't think this argument that we just heard, I don't recall seeing that made.
You don't what? You don't what?
I don't recall seeing the argument made that they are actually subsidizing this service. The orders and the briefs talk about the new lease capacity that's being created by the new facilities, the compression and the metering stations and so on. And in this case, as the court understands, the Tennessee as the lessee is, or I should say, Southern as the lessor is bearing all the risk. If anything goes wrong with this, if the contract falls through, something happens, the general system ratepayers, I should say, the petitioners here are transportation service ratepayers who are paying the system rates that are designed and have been designed in the past to pay for the service that they receive. The lease capacity is a property interest that will be held by Tennessee. It is not transportation service. It's very clear. Lease capacity is a property interest. It has different rights than transportation service. It has different billing than transportation service. So what the commission did in this case was approve the lease and the rates for the lease capacity. That has no effect on the transportation rates that system service customers such as the petitioners are paying. They're fully insulated from any risk if something goes wrong with this lease transaction. That is on Southern. It is between Southern and Tennessee, and these the municipals and the other system transportation service ratepayers are not paying for that. And so the commission said, as Your Honors said, that the costs and the revenues go together. The general transportation service customers paying system rates are not entitled to the revenues from the lease capacity because that they aren't paying the costs for the lease capacity or bearing any of the risk. So that's the commission's position on this issue.
Has this been this distinction between property rights and services been the commission's position in past proceedings?
Yes, yes. I think it goes all the way back to the certificate policy statement.
To which?
Oh, I think it's in the certificate policy or the lease policy that we discussed in our brief, which both go back some decades, I believe. Yes. And certainly
2007?
Well, yeah, possibly even before that, but the commission clarified in Gulf South and in subsequent cases, and I don't think anyone can point to a case after that, Gulf South in 2007, where the commission hasn't segregated the costs and revenues from the lease, separate from
well, but
transportation.
on the theory that this is a sale of property rights?
I'm sorry?
That the lease is a transfer of property rights.
It's a property interest, yes.
That is the theory underlying everything from Gulf South forward?
Yes. And the commission, I think, explains that, among other places, in the certificate order at JA 21, 22, 23, talks about what a lease is, how it differs from transportation service. It is a property interest that the lessee holds, but it also comes with fewer rights in some respects than firm transportation service with regard to secondary points, capacity release, things like that. It is a different animal, and it is treated as a different animal. If there are no more questions on the lease,
Is it possible to lower the podium just a little more? Because I think if the microphone's below you, that voice carries comes through a little more.
Is that better?
I think so, as long as you speak into it. Yeah, thanks.
I can also speak louder. I often do. So with respect to the connected actions, this court has...
Let me just stay with this for a second.
Sure.
So if there is a catastrophe such that the property that's been leased is unusable. That loss falls entirely on the lessee.
I think it falls on the lessor, on Southern, and whatever agreement they have with the lessee to cover that. Yeah, I don't know the exact terms. The point being that the risk is entirely on the lease side between Southern and Tennessee, and not
The ratepayers.
on the system ratepayers, exactly, the transportation service rates. The ins and outs of who exactly would bear that catastrophe as between Southern and Tennessee, I'm not sure, but I can tell you that it would not be the system ratepayer. So with regard to connected actions, I think looking at the body of cases, Delaware Riverkeeper 2014, City of Boston, and other cases from this court, the Evangeline pipeline is functionally and temporally separate from any of the other projects. They aren't all tied together. It serves the terminal as a customer, but the terminal was already approved before this project was even proposed. Or I think it was approved before it even held an open season to determine what pipelines might serve it in the future. Now, interestingly, I don't think there was even a rehearing order challenge in the terminal approval proceeding, and there was no appeal from that. So the terminal was approved, had an environmental impact statement, and was approved before before it found the pipelines to serve it, and then they separately proposed their projects to serve it using different transportation networks, different sources, different paths, and they're different companies. They just all contracted with the same customer, but they are not linked to that in the sense that you would do an environmental impact statement. Now, that said, in this environmental impact statement for the Evangeline project, it did include the information about the terminal from its environmental impact statement in the discussion of cumulative impacts.
Who did that? Was that the DOEs?
No, I mean,
You said
DOE
included the environmental analysis of the terminal, right?
right, so
Didn't
the commission,
DOE do that?
well, the commission had to approve the construction of the terminal under its authority under Section 3. It prepared the environmental impact statement. DOE was a cooperating agency in the terminal impact statement, and in fact adopted that as its own in its order 4446 and did its own analysis, but it cooperated in the preparation and adopted and then expanded upon the environmental impact statement for the terminal.
And
Now
that was
here,
just the construction of the terminal, not the continued operation.
right, but it is actually, that is a separate proceeding. DOE is also a cooperating agency in that one. So DOE was a cooperating agency in the terminal impact statement, and in the, I don't remember if it's an impact statement or an environmental assessment, whatever's being done for the terminal amendment, DOE is a cooperating agency in that, and will use that in its opinion regarding increased exports. As to Evangeline Pass, DOE is not a cooperating agency because it already approved the exports, so it's not involved in this. But the commission, as part of preparing a full hard look at this project, in the Evangeline Pass analysis, included anything that came before and even other projects that were ongoing. So in the environmental impact statement, it included information about the terminal from that prior impact statement. It included information about the Columbia Gulf East Lateral Express pipeline that had been proposed. It included that, I think, both in the environmental impact statement and in the order. And then later, when Texas Eastern proposed its Venice Extension project, which is still under consideration, the commission looked at the draft environmental impact statement from that so that it could address fully any potential cumulative impacts in the rehearing order. So the information it discusses in the cumulative impact section of the rehearing order, it draws upon the draft environmental impact statement for that other pipeline. So the commission did take a full hard look at any potential cumulative impacts, but that is not the same as saying that these are connected actions that must be treated all in a single proceeding.
What is the practical difference between those two?
I'm not sure. honestly. I mean, the commission is just trying to take a hard look overall. So I don't know exactly what it would be expected to do differently were it to treat any or all of these actions as connected. But it has, if we look at the environmental impact statement discussion of the East Lateral Express project, and if you look at the rehearing order talking about the draft impact statement in the Venice extension order, the commission takes quite a hard look at it, points out actually some of these facilities aren't even physically near each other for a lot of the geographically confined considerations, because none of these connect to the terminal. To clarify, the terminal has its own pipeline that was approved in its proceeding, the Gator Express. It has 2 legs. So those are the feeders to the terminal. None of these projects connect to the terminal. They all connect.
They all feed into that.
Into Gator Express, and not even in the same places. So one of the legs of Gator Express was to connect with the Tennessee system, including some capacity that was already there, and then now this capacity in the Evangeline Pass project. The other leg was to connect with Texas Eastern, and that's where Venice extension will connect. Neither leg connected to Columbia Gulf, so Columbia Gulf on the East Lateral Express is building to it and will join on the same platform where it's connecting with Texas Eastern. So you have Texas Eastern and Columbia Gulf at one platform. You have Tennessee connecting at the end of the other leg of the Gator Express. So they're all building to the project, but they're all separate companies with separate contracts and separate agreements with the terminal for what to provide, and being built on different timelines and in different physical areas. And they don't link up as in like the Delaware Riverkeeper segmented linear.
In the city of Boston case, which is quoted in the rehearing order here, it says the test asks, this is the test of substantial independent utility. The test asks whether, quote, whether one project will serve a significant purpose, even if a second related project is not built. What purpose would the pipelines here serve, Evangeline and so on, if the terminal had not been built?
Well, we do concede that while the terminal is independent from whatever pipelines it might have chosen to serve it, we don't contend that Evangeline Pass doesn't depend on the terminal existing. The terminal, of course, was already approved before this proceeding even began.
Right, but the Evangeline depends upon there being a terminal there to serve.
It does, but
Okay, so
we don't have.
So how does it meet the test of something that would have been built even if the other portion that here, the terminal, had not been built?
Well, we don't have a case that addresses this. So we don't know whether that independence has to be both ways. We don't have a case that says that if it's just one way, that can't count. If we look at all the factors, like the timing, the function, the commercial and financial independence, and all the other factors, it's not simply, does it depend on that, but what does it have in common with it?
Well, here's what the commission said in Food and Water Watch. Well, actually, it's the court speaking about the commission. The commission reasonably determined that the projects have independent utility, i.e. that, quote, quoting the commission, one project will serve a significant purpose even if a second related project is not built, close quote. Commission found that each project would have gone forward absent the other.
Well,
You can't say that here.
No, but here we have the second project. We're not talking about the first project and something that needs to be built later. We are talking about the second project. So we can see that we don't have a case.
What do you mean? Is that one's later than the other? Is that it?
What's that?
I'm not sure of your point, that one here comes later than the other?
Well, it's just not that we have a project in front of us that depends on something else to be done in the future. This is
Right, it's been done.
It's been done.
But the question is, I thought the question was, would these pipelines have been built had there been no terminal, to which the answer would be no?
I think we have to say the answer there is no, but I don't think that's the end of the inquiry. We don't have case law on point for that, but we do have all the factors that the court considers, and it is a balancing test, because in Food and Water Watch, the temporal issue there was equivocal in the court's words, but the other factors that you look at on balance made it appear to be not connected. And so we do look at things like the function, the commercial and financial. Again, these pipeline projects are separate from each other, separate companies, separate paths and everything. they did all contract with the same end customer. They're not being built by Venture Global. They're not owned by Venture Global. They're just someone who contracted with the terminal to deliver to it. And again, the court did note in City of Boston, among other cases, that if we don't know, for instance, when we're looking at the terminal, if we don't know what pipelines are going to be involved, the court's language was later projects can fully account for the cumulative impacts when those effects become better known. And that's where the commission demonstrates the rigor of its analysis here, in that it made sure in the cumulative impacts to consider every possible one of these projects as information about them became known, to the extent that in the rehearing order, all we had was a draft environmental impact statement for Venice extension, and the court still, or the commission still devoted something like 7 paragraphs to discussing it.
So you're not aware that that analysis would have differed in any way if the various projects were treated as connected?
I think that's right. I don't think it would have been different.
So from the commission's perspective, nothing's at stake actually in the connectedness inquiry. I mean, whether you have to do it over would be, but.
Well, I wouldn't say, I wouldn't want to, I'd have to think through what impact it might have for other cases. But I think as far as considering whether the commission met its obligation to take a hard look, it did, whether we want to call it connected or call it what it looked at and how it analyzed under the cumulative impacts. I think the point is that the commission fulfilled its NEPA responsibilities in the case.
And then you mentioned a couple times that part of what feeds into the commission's perspective that there's non-connectedness here is that they're separate companies. Mm-hmm. And are there other cases in which, even though they're separate companies, the projects are still treated as connected?
Not in the key precedents that I am aware of, the ones that we looked at. Boston, Food and Water Watch, I'm not aware of one where it's been different.
And still treated.
Because it tends to come up when it's the same company and they've got several projects and maybe they're near each other, even if they're not lined up, and that's where it comes up. So it is one of the facts, and it goes to the functional functional discussion. And the commission alluded to, I mean, it did say something about not being the same company in, I believe, paragraph 40 of the rehearing order. I know I looked at paragraphs 40 and 42, where the commission is suggesting that that is one of the indicators that it was looking at. I mean, and it just makes sense when you're comparing it to something like Delaware Riverkeeper, where it was one company that was marketing it as a single pipeline.
And you don't take issue with the proposition that in order to operate it, to achieve its full potential, that all of these various projects, even if they're coming from different companies, that the inputs feed into the full potential?
I know that's certainly why the terminal contracted with them. I can't categorically say that it couldn't get released capacity or some kind of secondary occasionally from someone else if it was cheaper, because it does have interconnects with different systems. But certainly it did enter into these contracts with the intention of being able to maximize its options, because they are different systems. They're bringing gas from different places. There may be times that they're getting more from Tennessee, which draws not only from the Appalachian region, but it can connect with the mid-continent system in Oklahoma. Maybe it has access to something that Texas Eastern doesn't, or wherever Texas Eastern is bringing its gas from. So I think any business is going to want to have options. But we don't have a finding here about what percentage of the terminal capacity. Does it have to be running 100% 24/7 to mathematically make sense, or is there some amount lower than that? We don't have that data. I don't think there's any basis to assume that it would be running flat out 100% all the time, but we just don't know that.
Can we just talk a second about effects, unless there's further questions about this? So can you just tell us what's the current status, or do you have a sense of what the current status is on the review of the 100,000?
It's ongoing. I don't know that there's been any updates since what we have, where it was reverted to draft status, and the fact that it's still ongoing, we think it further supports what the commission has been saying about the difficulty of this. The fact that the commission is continuing to grapple with these issues and consider ways to add even more to its environmental analysis. It just shows that the commission is trying to be rigorous about this and responsive to what the court has required. We believe that the analysis in this case does everything that this court has required in past cases or found the commission deficient for not doing. The commission quantified the emissions with aggressive maximum assumptions and compared it to national and state, regional emissions and goals. And it did discuss the social cost of carbon, and it still continues to find that not appropriate for the commission to make project level analysis. But it is still considering ways to do that. And
I mean, it did do all the things that you said it did, but then at the end of the day, it didn't tell us how much that matters. And that seems like it's a pretty significant. I'm not
right.
saying that whether I'm not concluding whether that's necessary or not, but that seems. It's hard to say that that's immaterial because the whole point of it is for an agency to lend its expertise to the matter.
I mean, what I can point out is that in both paragraph 98 of the certificate order and I forget exactly where in the rehearing order, the commission did say that overall, considering everything looking at this project, this is an environmentally acceptable action. And another thing I would note is that all 5 commissioners at the time agreed, even if they didn't necessarily agree on every aspect of how or why, there were no dissents on this project.
Isn't the determination of significance a statutory obligation?
Well, it is with respect to performing, whether you do an environmental impact statement, which of course we did. I think the commission has to include this discussion, but I don't believe the court.
I thought the regulation uses the word significant too.
You have to discuss, I think it says you have to discuss the significance.
Right.
And the commission discusses as much as it can here, but the court
I mean, it's hard to say it discusses this. It discusses a lot of things that would inform significance.
Yes, but it has not determined whether or how to make that ultimate determination if it needs to. And this, I don't think there's a case where this court has said that it has to, and that this analysis doesn't represent a hard look.
What's your response to petitioner's argument that you do need to? He says you just need to make a decision.
Well, that's all well and good to say, but we don't have a court case that says we have to take that step. And the commission
What is your argument for why this court should not say that in this case?
Because the commission still doesn't believe it has a tool that is appropriate for that, and it is trying to determine whether it can be appropriate, whether that or some other tool could be appropriate for that, but it isn't there yet. And the commission is a bipartisan body that has to come to some kind of, if not consensus, at least a majority.
I mean, maybe petitioner would say until you figure it out, you just can't certify things.
I don't know what the support for that is, so
Why is that wrong?
Well,
These are pretty, these are not hostile questions.
No, I know.
I'm giving you the opportunity to make your case.
And I think the commission's answer has just been, we just don't have the tool to do that, but we take a hard look at this project and we still think it's an environmentally
And he might say, the petitioner might say, just don't certify anything until you figure it out.
I don't know what the basis for, I mean, if the commission takes a hard look under NEPA, then it's fulfilled its NEPA.
That's question begging, or maybe his point is you can't take a hard look until you have figured it out.
Well, I disagree with that. Yeah, I mean, because.
Why do you disagree?
Whether or not a particular project, whether its emissions levels are significant, whatever that might mean, I think the commission doesn't think that's, that ultimate finding is necessary to be able to make a finding that something is in.
But why? I'll stop.
Beyond what the
Maybe-
commission
maybe
has said,
intervener
I can't
can help.
supply something beyond what the commission itself.
But
has
you
said.
must think that it doesn't matter as long as there's the conclusion in paragraph 98. I mean, that has to be the commission's position.
Well, what
That-
paragraph 98 tells us is that all 5 commissioners found this environmentally acceptable.
Right, and so it has to be that you think that as long as there's a bottom line conclusion that it's environmentally acceptable, then it doesn't matter if there's a sub-conclusion as to the significance of some aspect of that.
I think that's right.
How could it not be? I mean, it
Well,
seems
right,
like
I
it
mean,
has to be.
right, yeah,
Otherwise, you would lose, right?
Yes.
Isn't
So it ha-
significant, I'm sorry.
Go ahead, please.
Isn't significance also the criterion for moving past a environmental assessment to go on to an EIS?
Well, of course, and here we did that, so
I
that.
understand that,
right,
but there
yes.
must be some criterion by
Oh,
which
it
we
is.
decide whether to do that.
Yeah, well, I don't know what the commission, when the commission took the policy statement back to draft, it said it wouldn't apply it in currently pending cases, but it still did the environmental impact statement here anyway. And I believe it did with other similar projects. I know it did with East Lateral Express.
Okay, and sometimes it doesn't do an EIS, and some things that it determines don't have a significant impact, right?
Right.
So it must be some criterion that's using to say some EAs present as significant and some an insignificant.
It does, and I don't know what those are because it didn't bother with that here because it just went to the environmental impact statement. And the language that the commission used at the time, I'm not sure whether I have it flagged, but the commission said that, because initially it did do an environmental assessment for this project, and then it issued a notice, which is in the record. I just don't remember. Here it is, JA 333, where the commission said, staff will prepare an environmental impact statement. It will assist the commission in its consideration of the project's contribution to climate change and its decision-making process to determine whether the project is in the public convenience and necessity. And that just reflects the commission striving to comply with a number of this court's cases and giving the robust discussion of all the different facets that it had not done in the environmental assessment. So it made that determination in this case, even though it explicitly was not applying the policy of being the 100,000 or more. It went ahead and did it in this case regardless. So
it sounds like what the commission is doing is there's some situations in which the commission thinks it's just insignificant. And then there's other situations in which the commission thinks we can't just say at the threshold that it's insignificant, but we're also not going to say whether it's significant. And for those cases, it's just going to do an environmental impact statement to cover itself. Is that essentially what's going on?
I do know that in the only case I'm aware of, and counsel suggested there might be a couple others, maybe there are. I do know in the Northern Natural case, the commission went ahead and did it in that case, and it was
Went ahead and did, and
an insignificance finding.
yeah,
Because the numbers were minuscule. I think if you add the construction and operation of that pipeline, it's about 1/10 of the construction and operation of Evangeline Pass. So there is some amount like that where the commission, at least the commission at the time, said this isn't even worth.
right. I'm just saying,
arguing
in
about
answer to
this.
Judge Ginsburg's question, the commission's making a determination of significance in some cases because it's saying in some cases that it's just too insignificant.
If it's patently so tiny that it's
Right.
insignificance, maybe that's an easy.
Right, but it's not, the
but
converse of that is not,
It's not something that the commission has been prepared to do, and it's not something that the court is compelled to do. Even Northern Natural, that was the commission choosing to do it there. It wasn't because it was compelled to. But again, I would point out, unlike many of the projects this court sees, all 5 commissioners at the time agreed in both orders, even as they differed as to how they would end.
well, make sure my colleagues don't have additional questions. We'll hear from intervener.
We've exhausted.
Mr. O'Neill.
Oh, may it please the court, my name is Brian O'Neill and I represent the respondent interveners in the proceeding. By way of status, I mentioned before, the Plaquemines LNG project is under construction. It's been fully approved. It's been fully funded to the tune of $21 billion and expected in service date is the fourth quarter of next year.
Could you speak up a little, or could we turn the volume up a little bit? Something is not coming through.
I'll try to speak louder.
Thank you.
In any event, and in addition, the pipeline construction, at least with respect to the Tennessee and Southern, they expect that the construction will be in tune with and aligned with the in-service date next year with respect to the Plaquemines LNG facility. I'd like to touch upon a couple of issues with respect to each of the petitions for review here, following up on the connected actions discussion. I think it's important for the court to understand the reasoning behind the need for connected actions in some cases, and that's to avoid the segmentation by an agency in order to avoid environmental review, to segment a project into discrete sections and therefore avoid the overall environmental impact statement requirements. Here we have environmental impact statements. If you take into account all of the projects that petitioners have raised here in alleged connection, all of those projects have been the subject of final environmental impact statements. And indeed, with respect to the Evangeline Pass project, there was an environmental analysis, a draft environmental impact statement, a final environmental impact statement. And in that case, it's with respect to the other cases, the cumulative analysis took into account the Plaquemines facilities, the Gator Express pipeline facilities, the incident facilities that were before the court, as well as the other considered actions in connection with Texas Eastern proposal and Columbia proposal. One has to wonder, therefore, if there was a requirement that this be deemed to be a connected actions, what more would have to be done? And I don't know what it is. All I can tell you is that the commission here has fulfilled its NEPA obligations with respect to each of the projects that has been before it. And I point out also that the two of the projects, the Plaquemines LNG facilities that were approved along with the Gator Express pipeline, those are final actions that are not appealable. Similarly, the Columbia project that is one of the other links, one of the other supply links to the Gator Express pipeline, also has been approved by the commission, and that is a final action. It's no longer subject to appeal. Once again, one wonders, therefore, what is it that would need to be done? The only, with respect to the connected actions argument, and the only case that the petitioners have been able to point to is the Delaware Riverkeeper case, and the facts there are significantly different than what's before this court in this case.
Well, the regs make, or maybe it's the statute, differentiate between connected and cumulative effects. And in discussing this, you actually slid from talking about connectedness to talk about the cumulative effect. What is the difference?
Well, as I pointed out, that's what I think it's important for the court to recognize. The need for a consideration under the connected actions requirement is to consider all of the facilities in one environmental impact statement rather than dividing the projects up into discrete. Right. That's not the case here. That was the case, however, in the Delaware Riverkeeper.
Well, if here the commission were remanded to take a connected view of everything, at the very least, I suppose it would mean that whatever the emissions for each of these properties would be added together, correct?
I'd have to say perhaps.
And so it might be very different, might cause a very different view of whether something is significant if the something is this whole package rather than some piece of it.
Well, the commission, as I pointed out, did do an environmental impact statement with respect to all of these projects, each of them. And in addition, with respect to significance, it's somewhat of a straw man here. If the commission makes a determination that there is significance, if you will, What that means under NEPA is that they have to do an environmental impact statement. That's precisely what the commission did here with respect not only to the Evangeline Pass project, but to
Oh,
each of
that's,
the
so the significance determination in the sequence of events that runs from doing an assessment and then deciding whether it's significant enough to do an EIS, that's the only time where significance comes into play?
Well, under NEPA, it's what the extent of the environmental review has to be if there is a significance determination. And that's moving, as Your Honor pointed out earlier, from an environmental analysis to a full environmental impact review, which is, as I said, which has been done here.
I see. I guess this was a misimpression. I thought that they made that determination it's significant enough to do an EIS and then have to determine at the end of the EIS, is this a significant effect on the environment? But you're saying, no, that was already determined in the decision to make an EIS.
I believe that's right, Your Honor.
All right, well, we'll get Mr. Matthews in on that too.
Well, may I have a moment to address the other petition?
If you indulge in just
I'll
a
be
minute,
very,
please.
I'll be very brief. I think it's important on the capacity lease. The commission's policy, which has been followed consistently by the commission, is to treat leases as a property transaction, not as a rate for transportation. Here, we have brand new capacity that's been created, capacity that none of the shippers on the southern system want or need, including the petitioners here. So the fact is that they have been treated consistently. The commission treated this consistently with its policy. It has put the risk on Southern Natural with respect to this risk of all the costs, and has segregated the cost and the revenue from the cost of service associated with the development of rates for the existing customers. There's just no implication here with respect to the capacity lease on any of the rates, including the rates paid by petitioners here. And that's just an important distinction that I think seems to have been missed here. Also, I'd point out, in our brief, we cited the case, national fuel case, which is on all fours with our situation here for the commission. They treated it precisely the same way. We were criticized by petitioners for alleging this is a post hoc rationalization. In fact, the commission considered that both their order and the order.
I know we're running long on time, but can I ask you the question that I asked FERC with regard to the climate impact, the climate significance? It seems to me the petitioners are saying FERC has just got to make a decision, some decision, and that can then be critiqued or assessed. And until they do it, I guess FERC should just not approve any projects. They have to figure this out first. There cannot be a hard look until they make a decision about what is significant. Well, what is your response to that?
I'd answer it this way. I think here, the fact is that the commission did decide to do an environmental impact statement. That's what's required if there's a significance determination. In essence, therefore, in these cases, the commission has, without announcing it, actually reached a conclusion that there is a significant factor here, and it needs to be addressed by virtue of preparing environmental.
I think that's right. Okay.
Okay, thank you, Mr. O'Neill. Mr. Matthews, we'll start with 3 minutes for rebuttal.
Thank you, Your Honor. I'd like to first address what would have been required in the connected action analysis. It's missing from cumulatives. FERC interprets cumulative actions to only include effects that overlap in time and space. And FERC explains that in the EIS at JA 440 here. So for wetlands, for example, FERC looked at the analysis of the Evangeline Pass pipeline and said, this is in a different watershed than the other projects that are at issue here. And FERC concluded that the wetlands impacts will not overlap. So it didn't discuss the wetlands impacts of the other projects because it said they're happening someplace else. No one is simultaneously exposed to the same effects. The JA 443 to 444. We're not challenging that as adequacy of that as applied to cumulative impacts, but connected action says fine, maybe they're in a different watershed, but if you approve one project, that still makes the other one more likely to happen. And you need to be aware of that before you start going down that road, before you open the barn door. And that big picture approach is especially important because on the benefit side, FERC is looking at the big picture. It's not drawing a line between the benefits provided by the pipeline and the benefits provided by the terminal. In explaining why the pipeline was in the public interest, the terminal said that it will enable exports, it will stimulate jobs in gas production, that it will help U.S. balance of trade. All these other effects that the pipeline only provides if it is going to a terminal that then exports the gas. Those statements are JA 12 and 86 to 87. So if FERC is going to say, when it looks at any piece of this project, here are the benefits that the kind of big enterprise provides, and those outweigh the harms of this individual segment. And then it moves to the next segment. It says the big picture benefits still outweigh the individual harms. And it moves to the next segment. It says the big picture benefits outweigh the individual harms. It's not making an apples to apples comparison. And so that's why, even if they don't overlap in the same watershed or if the air pollution doesn't hit the same communities, FERC needs to look at the total amount of the impacts of the connected actions before it approves the individual projects. I'd also like to just address indirect effects. I know we didn't discuss that briefly, but we're happy to rest on the briefs for explaining why this case is more like Sable Trail and City of Oberlin. But there's an easier way to address indirect effects and the obligation to go upstream, which is that, as I said, FERC is arguing that this pipeline is in the public interest because it will support jobs in gas production. So if FERC is going to say that we can look at the benefits of gas production, FERC can't make a public citizen argument saying that it lacks the authority to consider the environmental effects of that additional gas production as well.
On climate significance, are you going to?
I'm happy to go there.
So I've been kind of describing your argument, and
I'd like to
describing it inaccurately. So
put a little nuance on the argument is that we don't think that FERC requires, or that NEPA requires FERC to do the impossible. So if FERC has to either make a decision one way or the other, or say that it can't. If FERC said there really is no way for us to do this.
Why is it not good enough for FERC to say we can't yet?
Because FERC hasn't even said we can't yet. FERC hasn't said, when FERC has said we've got a menu of options and we haven't chosen which one to pick yet. And the orders here are explicit about that. And then Commissioner Glick's concurrence says the only reason I'm joining this order is because we are not saying we don't know how to assess significance. I'm joining it because we're saying we're not going to do it, you know, we're still picking the best way. So that
so you think we can't yet would be okay?
I think that if they said we really can't, that, like, you know,
I don't know.
Maybe this
really
can't,
but I don't know what's the difference between really can't and can't. I'm just trying to get to.
So if they could explain why, like what's coming. So like if they had said, if this case was in 2010 and there hadn't been the interagency working group on social cost of carbon, they said, we don't know how to do this, but like once we get some numbers from TEQ, then in future cases, maybe that would be a method, but it's not available now. But like NEPA wouldn't necessarily require FERC to come up with numbers for what the social cost of carbon could be in isolation. And even that's a bit of an overstatement because part of the reason social cost of carbon was developed was in response to the Center for Biological Diversity versus National Highway Safety Transportation Administration case, where they said, actually, you do need to come up with a way to figure this out.
Mr. Matthews, if, as I was just given to understand or misunderstand, the significance question arises in determining whether to go beyond an environmental assessment to an EIS. They've done that here. Why do they need to say anything? So
a separate NEPA regulation. So the threshold question of whether to prepare an environmental impact statement is, are there going to be any significant impacts? It doesn't have to be, did you find, you know, they could have said, well, this is going to have significant wetlands impacts, therefore we're doing an EIS. That doesn't entail any conclusion about whether the greenhouse gas impacts are significant. There is a separate...
What compels that determination?
There's a separate regulation. I want to say it's 1502.16. It's in our briefs, and we cite it when we're responding to the intervener's argument that says, once you're in the EIS, for every individual effect, you need to discuss the significance of that individual effect. And FERC's practice is that significance determination, the significance of individual effects matters because it shapes the contours of how FERC addresses mitigation, alternatives, et cetera. I see that maybe if I can clarify that you were asking why did FERC do the EIS here and to reluctantly give FERC some credit. The regulations at the time said that an EIS was required unless FERC could affirmatively conclude that all impacts were insignificant. In this case, and possibly a little bit before in 2021, FERC, after much urging from our part, although I can't say we necessarily get the credit, recognized that if it was not going to take a position as to whether greenhouse gas emissions were significant or not, I believe FERC explained that that was the reason why it was then switching to doing environmental impact statements, because it couldn't make the affirmative finding of insignificance for all impacts.
Thank you.
Do my colleagues have additional questions this time?
I guess not.
Thank you, Mr. Matthews. Mr. Elliott, we'll give you 2 minutes for your rebuttal.
Thank you. I wanted to touch on the question of property and came up in FERC Council's argument. The property interest here is a right to inject gas at certain points, remove gas at certain other points on the Southern natural gas existing pipeline system. The capacity lease here, section 2.2, that's it, page 213 of the joint appendix, is quite explicit on this. It's not a lease of facilities, it's a lease of capacity rights. So the property interest is this inchoate right to inject and remove gas from the existing pipeline system. There's no lease of facilities in the accounting treatment, which is in Exhibit Y to the application, and it's addressed in paragraph 68 of the certificate order. And that's Exhibit Y is page 243 of the joint appendix. There's no transfer of property. So there's no property is being transferred to Southern Tennessee. The rate base of Southern natural gas is going to still contain 100% of its pipeline. Nothing's being transferred to Tennessee. That's part of the subsidy that existing customers are essentially doing. The rate base for the other bucket of costs is just the compressor and the metering stations, the $171 million. So there are two buckets of costs, but they're two rate bases. But the interest really, the bulk of the costs of Southern natural gas are staying with the existing customers. So talking about a transfer of property to Tennessee is not really true.
Well, if I lease 3 floors of a 10-story building,
I'm sorry, I didn't quite.
if I lease 3 stories of a 10-story building, right, don't I have a property right?
They have the property right to transfer.
I can use it, I can fill it, I cannot fill it.
Yes,
right?
yes, but it's a right to use the existing pipeline facility that's still in the existing customer's rate base. It's and that's the nature of the incremental service. I mean, FERC's argument basically is that lease prices are not cost-based, and therefore our rate-making policies don't apply. But they really never draw the line. We're not challenging the lease price. They can lease it at whatever price they can want to agree with the lessor and the lessee. The second issue is, what do you do with the lease revenue when setting cost-based rates? And that's where FERC never addresses the issue.
Yeah.
The precedent, Rockies Express and Natural, says credit the revenues to avoid double recovery, over recovery.
Okay.
Those have never been overruled.
Make sure my colleagues don't have additional questions at this time. Okay. Thank you, counsel. Thank you to all counsel. We'll take this case under submission. We'll take a brief recess.
Testing. This honorable court is again in session. Case number 22-7140. John N. Xereas, appellant, versus Marjorie A. Heiss et al. Mr. A. Holt for the appellant, Mr. O'Neill for the appellate.
Morning, counsel. Mr. A. Holt, please proceed when you're ready.
Morning, Your Honors. Brent A. Holt on behalf of appellant John Xereas. Your Honors, this case is somewhat unusually found itself before this court as a breach of fiduciary case in the District of Columbia. It's initially filed back in 2012, went to trial in 2018 after the breach of fiduciary count 21 of the amended complaint dismissed. Eventually, the verdict was entered in favor of my client. Reduced. The case went up on appeal, partially by my client, and the case was overturned on the dismissal of my client's breach of fiduciary count. That count was thereafter remanded for trial in the district court. District court immediately thereafter, or shortly thereafter, the defendants filed a motion for summary judgment. District court granted that count, and that is why we're here. The court ruled on summary judgment two bases. First, that the damages presented on behalf of the Xereas would essentially amount to double recovery of the first trial. Secondly, the district court ruled there was no evidence of either a breach or proximate cause of damages. On both counts, on both rationale, the court erred. There was ample evidence for the district court to allow the case to go forward to trial in support of this breach of fiduciary count. There was a report that was submitted as part of the defendant's motion for summary judgment. Hundreds of pages of a report of the evidence of this breach of fiduciary duty. Essentially was $6 million in unaccounted for funds in the LLC. Those funds to which my client would have been entitled to his pro rata share had these funds properly been in the LLC. And that is why we're here today, because these funds, it's undisputed and unrefuted testimony and report that these funds were improperly accounted for, that they should have been in the LLC, that Mr. Xereas was entitled to his share of these funds, and that is a proper basis and proper support for the breach of fiduciary account. There is no dispute in this case that the defendants were in control of the LLC. Defendants Heiss and Dawson were in control of the LLC. They were managing the LLC. They were in control of these funds that were coming into the LLC on a daily basis throughout the course of the events leading up to trial. There is indisputed evidence based on the unrefuted report of Mr. Morrissey that these funds were missing, $6 million worth of these funds. And these funds were undoubtedly because of the failure of the defendants to safeguard them. They were missing. So on the double recovery issue, I apologize. On the double recovery issue, the first verdict at trial was $106,000, $600,000 based on a failure to pay for work done. That was later reduced to $45,000.
Now, when you say failure to pay for work done, I'm looking at paragraph 285 of the complaint.
Yes, sir.
And the claim here is the plaintiff has suffered damages caused by the breaches, including but not limited to loss of salary, compensation, earnings. That all seems to be one thing, more or less, and proceeds from the operation of the LLC.
Sure.
And so whatever the damages returned apparently were meant to cover not only his wrongful termination damages, but his loss of proceeds from the operation.
That would be correct, Your Honor. It would also be legitimate proceeds from the
Okay,
operation.
well then, in that case, he's already recovered.
No, he is not. He's not recovered, Your Honor. The specific damages that he seeks for this breach of fiduciary are not necessarily the proceeds from the operation of the LLC that would have been coverable under the breach contract. They are, in fact, the proceeds that were unaccounted for by Heiss and Dawson that are in the Morrissey report. The Morrissey report significantly was specifically stricken by the district court before the jury was able to rule.
Right, so the Morrissey report was not before the jury.
Not before.
Okay, and the jury made an award based on the complaint.
Based on the allegations in the complaint and the evidence presented at trial.
Yeah, but without the Morrissey report, what was the evidence at trial bearing on the problems suggested by the Morrissey report?
There was no additional evidence based on those issues that are contained in the Morrissey report. That's the problem. They couldn't have, Mr. Xereas could not have recovered these same damages at trial the first time because there was no evidence from which the jury could have based their finding at the first trial on these same damages.
Just your allegations.
There are allegations in the complaint, but you can have allegations in a complaint that are thereafter not supported by evidence at trial because the jury does not hear that evidence.
Right, and that seems to be what happened. You got the allegation, you got an award based on the claims for loss of salary, et cetera, and loss of proceeds from the operation.
Certainly, Your Honor. And you plead in the alternative.
So what is the latter? What is the latter if it's not
well,
the money?
Your Honor, had that evidence been presented at the first trial, it could have been proceeds from the operation. But because it wasn't, and because the defendants or the plaintiff proceeded to trial on that breach of contract claim, it would have been, something else could have been duplicative of the damage, the loss of salary and compensation. These are broad terms when you say compensation. That could be distributions, That could be salary, things like that. Compensation comes in various forms, but the question for this court is what evidence was presented at trial? And the evidence that we know that was not presented because it was stricken by the district court at the first trial was the Morrissey report, which the plaintiff is now relying on. It was contained in defendant's motion for summary judgment and has never been heard by any fact finder, so it is literally impossible for the Morrissey report to be double recovery. If my client were to go to trial a second time and receive everything in the Morrissey report that the Morrissey report says he's entitled to with regard to these lost funds. There's some other things that are related to trademark issues and things like that we're no longer claiming. But just with regard to the breach of fiduciary duty count, if my client were to recover all of those funds, which are about, I believe, $1.5 million are his share of those, that would consist of nothing, absolutely zero amounts that were claimed at the first trial because, quite frankly, the court both dismissed the breach of fiduciary count
Right,
and limited the evidence.
When you're arguing that the court erred in granting summary judgment on the ground that your client had not shown evidence of a breach of fiduciary duty, are you arguing that the Morrissey report should have been admitted? I don't think so. I think that's come and gone, correct?
No, the Morrissey report will be used at the second trial.
I see. Okay, so
And it's in fact used as evidence at the summary judgment stage, in this case, unrefuted. If Your Honor's finished.
so go ahead.
With regard to the district court ruling on the evidence of breach causation, the district court seemed very concerned that there was no direct evidence of self-dealing. And the district court's correct that there's well, no, I won't say that. The district court's not correct for direct evidence. I think there potentially is direct evidence, but you have to draw an inference from that direct evidence. However, what we certainly have is circumstantial evidence. So we have two parties that are in control of an LLC. We have an LLC that is clearly missing substantial funds, and we have no explanation for why these funds are missing. We have a forensic accountant reporting there were severe irregularities, red flags. There were missing funds, that there was improper accounting, that it fell below IRS standards, that it fell below the standards in the LLC agreement. And there's no explanation for this. And yet,
Can I just ask you, I know we're short on time, but let me just ask you, on the Morrissey report, the report says that it was meant to calculate damages, but not to determine liability. So then how does the Morrissey report feed into whether there was a breach of fiduciary duty?
So he was not going to be a determiner of liability. However, his findings are evidence of liability. So while he is not hired to assess liability, to come to a conclusion as to liability, his findings that there are substantial unaccounted for funds missing from this LLC are evidence of the breach of fiduciary duty. It is the duty under the district code for the member managers to account for all of the funds in the LLC. Morrissey's opinion, his report, shows that they did not account for all of the funds in the LLC. And it calculates those, and that's his role as a forensic accountant, to assess what happened here,
Well, I mean, there may be funds missing, so then that would tell you that it's possible that the reason funds are missing is because there's a breach of fiduciary duty. It's also possible that the reason funds are missing is something entirely unrelated to a breach of fiduciary duty.
Absolutely, Your Honor, and that is the very standard that should have been applied, that there are two reasonable conclusions that could be reached by this report.
Well, I didn't necessarily say that either of those conclusions was reasonable or not reasonable. I'm just spanning the spectrum of possibilities. And then you have to have enough evidence in the record to create a genuine issue on whether there's been a breach of fiduciary duty.
Yes, which the Morrissey report absolutely does create a genuine issue. It's unrefuted, quite frankly, Your Honor. You know, if the funds are missing, which they are, according to the record on summary judgment, funds are in fact missing. Morrissey gives various reasons that they're missing. There's not proper receipts for third-party expenditure. There's unaccounted for cash withdrawals that aren't attributed to him. All these things are irregularities. There's no dispute the funds are missing because there's been no effort to rebut that funds are missing. There is no dispute that funds are missing. So thereafter, you have an analysis that brings you to the two people in control are fiduciaries. They did not account for these missing funds. Therefore, reasonable conclusion reach is that there is either gross negligence or they're intentionally self-dealing. One of the two. That is a reasonable conclusion that a fact finder could reach based on these facts before the court at summary judgment, both on inference, circumstantial evidence. You don't need to have an instance where you say, aha, we found it in the defendant's account. That obviously is direct evidence. You see the paper trail where it goes. This is summary judgment. Even at trial, we wouldn't need that for a motion.
At least for some of these funds, when they went missing, was your client still in control?
Is my client in control?
When for a portion of these funds,
No.
So all the funds in the Morrissey report are funds that went missing after your client was out of control.
Yes. After Dawson and Heiss basically removed him from any control of the corporation. So I know we're short on time, so unless there's any further questions.
Sure. Unless my colleagues have further questions. Okay, we'll give you a little bit of time for rebuttal. Mr. O'Neill.
May it please the court, William O'Neill for defendants Marjorie, Heiss, Jeffrey Dawson. I'm going to address Mr. Morrissey's report in just a second. There's just a few things, preliminary matters I wanted to mention. The district court in this case granted summary judgment on three different bases, three different legal reasonings. The duplication of damages, the lack of any evidence of breach of fiduciary duty, and the lack of any evidence linking such a breach to the damages, so proximate
costs.
Yes. On any one of those three grounds, if this court finds that the district court's action was proper, then the judgment below would be affirmed. So we don't need to win all three. Any one of those reasons would be sufficient. I'm going to jump now to Mr. Morrissey's report because I think the plaintiff here has been fundamentally misrepresenting this report for years now. What Mr. Morrissey actually did was he took the LLC's QuickBooks accounting, pulled out every invoice that was captured in the LLC's accounting records, looked to see if an invoice had been produced during the litigation, and if he didn't find that invoice, he put it in the bucket of an unsupported expense. That is the entire exercise. He did it on different areas. He looked at the business had an ATM bank. They would take money out of the bank account, put it in the ATM. Funds would circle back into those accounts. And because the LLC did not have a record from the bank every time it took cash out of that account to put into the ATMs that were in the bar, he said those were unsupported. They then say that these are missing records. And there's one simple fact that refutes that statement. We asked one of the vendors for the company, Adams Birch. We gave them Mr. Morrissey's report. It listed $150,000 worth of invoices from Adams Birch. And we asked Adams Birch, what's going on with these invoices? Are these real? Did somebody create fake invoices? And they said, every one of those invoices were for work or products that we delivered to the bar Everyone was paid by the LLC, and every delivery was made that they paid for. And when I asked Mr. Morrissey in the supplemental appendix, we included the examination of Mr. Morrissey in the first jury trial, where I asked him, does the Adams-Birch testimony change your opinion? Those expenses are real. Vendor says they're real. Company says they're real. Does that change your opinion? He said, no, absolutely. Doesn't change my opinion at all. What Mr. Morrissey actually put together was a theory in search of facts. When plaintiff, Mr. Xereas' counsel stands here and says that funds are missing, they have no factual basis for that statement at all. There was no examination of Mr. Dawson's accounts, no examination of Mrs. Heiss's accounts. There was never even an allegation that they took money out of the LLC. In fact, the record shows that Mr. Dawson put $800,000 of his own money into the LLC after removing Mr. Xereas, just to keep the business afloat. And he's kept it afloat for the last 12 years. So when they say funds are missing, that is a factual inaccuracy. And I would recommend
Does Morrissey say that funds are missing?
He does not state that. He says only that this expenditure from the company's books doesn't have secondary backing. That is the full extent of his opinion. And I recommend to you in the lower court, before closing arguments, we had moved to strike Mr. Morrissey several times. There was a voir dire before Judge Robinson as to whether he would be allowed to testify. And prior to closing arguments, I again moved to strike Mr. Morrissey's testimony and just his testimony. The court was never entered. And at pages 182 through 186 of the appendix is the colloquy between myself, Judge Robinson, and counsel for plaintiff John Xereas. And the first thing is Judge Robinson has struggled with. It's the same thing they're doing here. They wanted to argue inferences with respect to the breach of contract. Breach of contract claim was the only one of the 26 claims that Mr. Xereas originally had in the Second Amendment complaint that survived to the jury. So the jury was only considering breach of contract. Judge Robinson first said to counsel for the plaintiff, I can't let you argue any inferences from Mr. Morrissey's report. You can't argue any inferences that a contract was breached based on what Mr. Morrissey testified. We then took a break before closing started, and when the parties came back before the judge, she said, she'd been thinking about it for an hour, and she didn't see any basis for Mr. Morrissey's testimony to be argued in closings at all. And what plaintiff's counsel said then was that they had voluntarily taken out all references to Mr. Morrissey from their closing. They didn't object to the judge's suggestion that he would be stricken, and instead they voluntarily withdrew his testimony. So even then, plaintiffs were admitting that Mr. Morrissey's testimony had no value, no probative value with respect to the breach of contract. And I would argue that the same is true here. The breach of contract claims and the breach of fiduciary duty claims are coterminous. They arrive from the same set of facts. Judge Wilkins, in the earlier decision, made that observation when he warned the district court on remand not to award duplicate damages. He noted that the breach of fiduciary duty claims relied, in their actual breach of fiduciary duty claim, they refer to all 300 paragraphs of the Second Amendment complaint as the basis for their breach of fiduciary duty. That includes, as we pointed out in our briefing, disagreements over the beer served. Every mundane thing that they threw into the Second Amendment complaint, they were alleging was a breach of fiduciary duty. And so those same things, as Judge Wilkins recognized, were the basis for the breach of contract. For that reason, Judge Wilkins recommended that the district court look hard at whether they were asking for the same damages again. They received from the jury all of the damages they sought for breach of contract. You're now coming in with a new theory, Mr. Morrissey's report. It's not, call it a new theory for purposes of this discussion, new theory. And what Judge Wilkins said was, you can come in with a new theory if you've already been paid your damages for a claim, and you restyle the claim and restyle the damages, it doesn't matter. You've already been paid. So I think that's an important point to consider. And the fact that Mr. Morrissey's report has already been examined closely by 2 district courts, both of them have found it wanting in evidentiary value. As judge in this action on summary judgment pending before the district court after reading, he said, Judge Morrissey didn't apportion any liability. He did not include any assessment of what these discrepancies meant, apportion liability, or alleged self-dealing by defendants. Judge Robinson concluded the same exact thing. Plaintiffs concluded the same exact thing when they voluntarily withdrew from the jury consideration of Mr. Morrissey's testimony. So every time they say that funds are missing, they don't have any evidence that funds are missing. They only have Mr. Morrissey's statements that compared the discovery in this case to the LLC's own books, and I didn't find a backup invoice. And as the district court here determined, sloppy bookkeeping is not a breach of fiduciary duty. One of the first bases that the judge in the district court used to grant summary judgment was the lack of any breach of fiduciary, any claims supporting a breach of fiduciary duty. And when that issue was raised on our motion for summary judgment, they came back with quotations from the second amended complaint and Mr. Morrissey's report. It's patently obvious that claims from statements included in the second amended complaint are not evidence. They're allegations. The judge dismissed those wholeheartedly. With respect to Mr. Morrissey's, he reached the same conclusion. Mr. Morrissey's report and testimony did not amount to evidence of a breach of fiduciary duty. The looking backwards from Mr. Morrissey.
So did you dispute the breach of fiduciary duty? Because it's...
In our motion, yes, Your Honor. The first thing we did was question what the plaintiff contended was the breach of fiduciary duty. As I said, when we looked at the second amended complaint, he said every fact alleged in there was a basis for a breach of fiduciary duty. So our motion questioned what was the breach of fiduciary duty and what was the...
Where's that in the appendix?
Well, the first heading in our motion, Your Honor, was the plaintiff lacks evidence of damages approximately caused by any alleged breach. But with respect to...
Where are you? Where are you reading from?
The appendix, page 213, 217, and 219 bring up the duplicate payments, the lack of any evidence of breach of fiduciary duty, the lack of approximate damages. So,
right, but
a further fact to consider...
Proximate cause is different from the element of breach.
Correct. But
so on the element of breach...
Yes, we questioned...
You just read the heading, which was, I think, is that on 217? Plaintiff lacks evidence of damages approximately caused by defendant's alleged breach of fiduciary duty.
Well, Your Honor, we questioned what they believed was the breach of fiduciary duty. And in their response to our motion, they devoted multiple pages to laying out what they thought the breach of fiduciary...
Well, they might have done that. So that's a different issue. I'm just wondering, just as a factual matter, did you dispute the element of breach?
I believe we did, Your Honor.
Where?
We raised that issue. We raised the issue of duplicate payments. We raised the issue of
but duplicate payments is also different. On the question
Yes.
of breach, where, just point me, just show me in the appendix where you disputed breach. I'm not saying you necessarily lose because of this. I'm just wanting to know.
I have
where?
references to pages 217 and 219 of the appendix.
Okay, then where where on 217? Because what 217 says is plaintiffs lack evidence of damages proximately caused by defendant's alleged breach of fiduciary duty.
That 217 is the reference to proximate cause. But
Right. So that one,
219,
okay, so 217, just to break it down.
correct.
You
I
said
bel-
217 and 219. It turns out 217 actually doesn't have anything.
It was the second part of the breach of fiduciary duty and lack of proximate cause. So 219, I believe, is a question, is raising the question of what they contend the breach of fiduciary duty is.
Where's that on 219?
Unfortunately, Your Honor, I don't have the appendix in front of me. I just have my notes.
Do you have it with you at all?
No,
I see.
Well, can
But-
I get your reaction to this sentence, which is on 217? Is even, let me make sure. Even if the act of removing Xereas as a managing member could be found to be a breach of fiduciary duty, Xereas is still required to produce evidence of damage different from the damages he collected. I'm not sure that that's enough to get you over the line in terms of
challenge.
saying there was no breach, but what's your argument for why that was enough of a challenge to?
Because we were left in the dark as to what he contended was an actual breach of fiduciary duty, because he alleged everything was a breach of fiduciary duty. His brief seems to suggest that we were obligated to come in and present admissible evidence on each of those 300 allegations and say that that's not a breach. Instead, what we did was we put him to his proof by raising the question of what is the breach of fiduciary duty, and putting the duty on him, who's got the burden of proof on this point, to come in and tell us what it is. Where's the evidence of a breach of fiduciary duty? In a large part, we were in an impossible situation to come in and present evidence on 300 different ideas. So, and the fact that they spent pages 794 to 95 talking about what the actual breach of fiduciary duty was in their briefing suggests, at least to me, Your Honor, that the issue was properly raised before the court. Opposing party responded to it, and the judge quite rightly addressed it in his summary judgment.
It's not the most natural, it strikes me as not the most natural means of preserving a breach of fiduciary duty claim to begin an argument with, even if there was a breach.
Your Honor, I'm not going to say I haven't gone back and read some of my motions a year later and tried to figure out exactly that could have been clearer. I will acknowledge. But we were attempting to challenge each element of both. Our emphasis certainly was on the damages.
Yeah.
But we at least raised the issue, we believe, significantly enough to put the plaintiff on notice, and he responded to that.
Yep, and you got a decision in your favor on it too.
Yes.
And I take all that. Okay. All right. See if my colleagues have additional questions for you.
Thank you very much.
Okay, thank you. Mr. O'Neill, Mr. Ahold, we'll give you 2 minutes for rebuttal.
Thank you again, Your Honors. I just want to briefly address the sum and substance of counsel's argument, attacking the credibility of the Morrissey. And I understand why they do that. They're entitled to do that, however, not on summary judgment. That is an issue for trial, the credibility of the brief. As far as the plaintiff's counsel at trial, whether or not they somehow waived the issue of the striking of the Morrissey, the record's very clear that they preserved that issue at trial, and that they did not intentionally not submit Morrissey to the jury in that case. And that's important on the double recovery issue. They were prevented from presenting that argument. Now, there is, I will concede that there is a segment where counsel for the plaintiff said that we are withdrawing our arguments after the court had already ruled that certain claims and counts were ruled on as a matter of judgment. Counsel considered it and said, well, it's probably not relevant to the remaining count based on the court's prior rulings. But then, very clearly, even after that concession, that they were not going to raise it at argument, the court separately struck the entirety of the testimony of Mr. Morrison. So there's no question that testimony was not presented first. And it wasn't a judgment as to the credibility of the testimony. It was a judgment as to the relevance of the testimony at the first trial. So to say that this court has twice determined that the report was essentially worthless, I think is a misstatement. The judge actually allowed the jury to hear the testimony because she gave it credibility, but then later, after her rulings limiting claims, struck the testimony as no longer relevant for the jury to consider. And with that being said, Your Honor, this case has been going on for 12 years now, I believe, not quite 12, 11 years. It's been up on appeal once, it's gone back down at once on a successful appeal. Breach of fiduciary duty belongs before a jury. That's what the court ruled, what this court ruled last time. There is no reason in this motion or in this opinion that testimony of Mr. Morrissey should not see the light of the jury. They can determine its credibility.
Okay.
Thank you.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.